So how's your day, guys? Are you up to learn something from treaties? Because if yes, then that would be our topic today. So treaty is defined as international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more instruments, and whatever its particular designation. In other words, it is an agreement between states, including international organizations of the state, intended to create legal rights and obligations of parties thereto. So, to understand treaty more, here are the words associated to it. First, we have the convention, then pact, protocol, agreement, arrangement, accord, final, general act, and exchange of notes. First, we have the codification. The law on treaties is contained in the 1969 Vienna Convention on the Law of Treaties, or VCLT. The law on treaties is contained in the 1969 Vienna Convention on the Law of Treaties. This means that the VCLT covers those treaties made after its entry into the force. So VCLT becomes the basis of those treaties. Then we have the status. Although a number of provisions in the VCLT are already customary international law, such as Article 26, which speaks of pacta sunt servanda, the entire VCLT itself is not yet customary international law because state practices shows that the rules set forth in the conventions are invariably relied upon the state. Next is parties. So only international agreements between states are governed by the VCLT. State laws or national laws are not covered because, again, treaties are agreement between two or more international states and not by the one state alone. Next slide is terminology. So the designation of an instrument as a treaty is usually reserved for those which contain agreements involving matters. First, we have the peace, then borders, extradition, friendship, and commerce. So when treaty is multilateral, it is usually designate or designed as convention, while if a treaty is subsidiary to treaty, it is called a protocol. Following is the modus vivendi. It refers informal agreements between states, usually involving peace. So first we have the final act, an instrument that records the winding up of the conference proceedings, or in layman's term, you can say it is a minute. Then we have the joint communique. It is an issuance by the minister to the press after the end of the meeting, or it constitutes to international agreement. Next is the importance of distinction. So different instruments or treaty come with different rights and obligations. By the way of example, where an instrument is not a treaty, a state cannot invoke the VCLT in its favor because, again, VCLT covered treaties only. Example is unilateral statements. So although most treaties require express consent of both parties, there have been instances where the unilateral statements of state representatives have been held as binding on the state itself with the force and effect of the treaty. So next is subsequent formalization. It is binding nature of any decisions made by the Organization of African Unity Mediation Commission. Then we have the forms. So treaty should be in writing, but a treaty that is unwritten shall not affect its legal force. Following are the bases. First is intent, an important factor when determining if the same is binding with the force of the treaty. Then we have the coverage. It covers only treaties executed between states. And lastly, we have the registration. Treaties after their entry into force shall be transmitted to the Secretariat of the United Nations for registration and publication. Next is the requisites for validity. So when we say requisites, it means requirements. So first requirement is the treaty-making capacity. Means every state possesses the capacity to conclude treaties as an attribute of sovereignty. So any recognized states can conduct valid and legal treaty among other recognized states as well. Next is the competence of the representative organ concluding the treaty. So it is the president who exercises the power, subject to the concurrence by two-thirds of the members of the Senate. So for example, our country, it does need full power to negotiate on behalf of the Philippines. However, the following persons do not require separate grant of full powers prior to the negotiating executive agreement or any amendment. So first we have the Secretary of Foreign Affairs, then the heads of diplomatic missions, and lastly, accredited Philippine representatives to an international conference, international organization, or any other organs. And parties must freely give consent. So first we have the following of the consent given. First we have the signature, then the exchange of instruments constituting a treaty, ratification, acceptance, approval, accession, and other means manifesting consent. Where the consent of a party has been given in error or induced through fraud on the party of the other, the treaty is voidable. So also, through corruption, treaty can be invalidated. So the following are the grounds of invalidation of treaty. So first we have the doctrine unequal treaties. So treaties which have been imposed by a state of unequal character is void. Then other vices of consent. So a treaty that was signed by an authorized representative can be invalidated by the state. Following is the domestic law not a shield. So state may not invoke its own domestic laws in order to escape treaty liabilities. Then we have the manifest violation. So violation is manifest if it is objectively evident to any state acting in accordance with normal practice and good faith in relation to that matter. Thus, mere clerical errors and mere errors in the state's judgment are not grounds for invalidating the treaty. First, we have the licit. Object and subject matters must be lawful within the commerce of nations and then the conformity with international law. However, the object is deemed illegal only when it contravenes or departs from the absolute or imperative rule or prohibition of international law. So following are the grounds of illegality. So first we have the doctrine of jus cogens. A treaty whose provisions contravene such norms or rules may be invalidated. Next is emerging jus cogens. The emergence of new jus cogens can and will invalidate an existing treaty repugnant to it or extremely unacceptable. Then lastly, we have the erga omnes obligations. They are allowed by the state to the international community. As such, state may not enter into any treaty that would result in its violation of an erga omnes obligation. Next slide is the ratification in accordance with the Constitution processes of the parties concerned. So Section 2, Article 7 of Philippine Constitution stated that no treaty or international agreement shall be valid and effective unless concurred by at least two-thirds votes of all members of the Senate. Then for invalidation of treaties under VCLT, grounds to invalidate a treaty may be classified as situation where the state did not freely give its consent, such as separability provision that render the treaty invalid can be removed. Those provisions should be separated and the rest of the treaty remains operable, provided the continued performance of the treaty is not unjust. However, no separation is allowed if there is a coercion of the state or its representative. Next, we have the treaties and executive agreements. So, treaties generally refer to basic political issues, while executive agreements refer to the adjustment of detail. An executive agreement may either be the presidential agreement or congressional executive agreement. So, if it is an executive agreement, there's no need for the two-thirds votes of the Senate. Next is the executive agreements covers. So they cover the commercial and consular relations, property relations, including intellectual property rights, postal matters, matters of navigation, the settlement of the private claims, and matters pertaining to tariff and trade. So the Visiting Forces Agreement is constitutional, having been duly concurred in the Philippine Senate. In case there is a dispute as to whether or not an international agreement is purely an executive agreement, the matter is referred to the Secretary of Foreign Affairs, next is to the Senate representative, then the Secretary of Foreign Affairs, and lastly to the President. Then we have the exchange of notes, so a record of routine agreement that has many similarities with the private law contract. The agreement consists of the exchange of two documents, each of the parties being in the possession of one signed by the representative of the other. So first we have the practical application. Treaties and executive agreements are difficult to distinguish. Despite of the seeming difference between treaties and executive agreements for academic purposes, in reality, it is difficult to tell them apart. Following is the making process of the treaty. So this is the brief steps on how to make treaty. So first we have the negotiation, followed by the signature, then ratification, and lastly the exchange of instruments of ratification. So let's tackle first the negotiation. So the representatives of the parties are usually armed with credential known as plen privajo, or full powers, which is a document emanating from competent authority of the state designating a person to represent the state for negotiating, adopting, or authenticating the text of a treaty. It could be the head of the state, head of the government, the foreign minister, the head of diplomatic mission, and the representative accredited by the Senate to an international conference. Next, we have the signing of treaty. The principle of alternate is observed, according to which the order of naming of the parties and the signature of the plenipotentiaries is varied so that each party is named and its plenipotentiary signs first in the copy of the instruments to be kept by it. First thing to happen is the adoption and authentication. So adoption takes place when the states that took part of the creation of the instrument certify that they have reached consensus to adopt the same. Next is the types of signature. It should be simple, where the instrument was signed initially but the state is not completely bound unless the signature is later ratified. Then the second type is the definitive, when the state is bound as soon as the instrument is signed, regardless of whatever it later ratifies the instrument or not. Following is the consequence of signature subject to ratification. So instrument is signed but not yet ratified, and such ratification is material to bind the state fully. Next step is the ratification. So this is the act by which the provision of the treaty are formally confirmed and approved by a state, and by which the state expresses its willingness to be bound by the treaty. So in the Philippines, the power to ratify a treaty is vested in the President, subject to concurrence by 2/3 of all the members of the Senate. The President, being head of the state, is regarded as the sole organ and authority in external relations and is the country's sole representative with foreign nations. So first we have the accession, or also known as the adhesion. This is the process by which a non-signatory state becomes a party to a treaty. Then we have the reservation. It is a unilateral statement made by the state when signing, ratifying, accepting, approving, or acceding to the treaty. Next step is the entry into force. A treaty enters into force in such manner and on such date as it may provide, or as the negotiating parties may agree. In the absence of such a provision, the treaty enters into force as soon as the consent of all parties to be bound by the treaty is established. So following are the reconsiderations. First is the domestic considerations. So the entry into force of the treaty cannot be hampered by the domestic laws, since a state cannot invoke domestic law to justify failing to perform a treaty. Then the exchange of the instruments of ratification. So consent is deemed established with the exchange of instruments of ratification or accession. Next is the registration with and publication by the United Nations. So every treaty and international agreements entered into by any member of United Nations should be registered as soon as possible with the Secretariat and published by it. So lastly, the Philippines domestic concern. So a treaty or executive agreement is only deemed to enter into force upon compliance with several domestic requirements, such as submission of signing of paper to the Department of Foreign Affairs and transmission of the agreement by the Department of Foreign Affairs to the endorsement of concerned agency. Okay, so when non-signatories may be bound by a treaty. So as a rule, treaties cannot impose obligations upon states not parties to them. However, states not originally parties to the agreement may become bound. Other states may also be bound by the terms of a treaty if linked by the most favored nation clause, under which a contracting state entitled to the clause may claim the benefits extended by the latter to another state in a separate agreement. Next is new state. Generally, a new state cannot be deemed to have any treaty obligation because it has yet to sign any instrument. However, regardless of the status, it must be remembered that all states are still bound by customary international law, which includes respect for the territorial integrity of the other states. Next slide is applicability. Later treaties, it is a later treaty may be invalidate an older treaty when they have conflicting provision. Then we have the specific treaties. It is generally understood to prevail over more general treaty when they have conflicting provisions. Next is the overlapping provisions. When treaties have overlapping provisions, they must be interpreted in a way that would harmonize them. If conflicts still present, the rules of specific treaty and later treaty must be applied. Then lastly, the dominance of UN or United Nations Charter. So pursuant to the Article 103 of UN Charter, the obligation of United Nations member as found in the Charter shall prevail over their treaty obligations in case of conflicts. Next slide is the fundamental principles of concerning treaties. So first is the territorial application. So a treaty is binding upon each party with respect to the entire territory of that party unless treaty reveals a different intention. Following is the pacta sunt servanda. It is required that treaties must be observed in a good faith. And lastly, we have the rebus sic stantibus. Contracting states' obligations under the treaty terminates when a vital fundamental change of circumstances occurs, thus allowing a state to unilaterally withdraw from a treaty. Next slide is the interpretation of treaty. So interpretation of treaty shall be interpreted in a good faith again. First, we have the retroactive effect. So a treaty shall have no retroactive effect except when expressively provided. Second is law at the time of interpretation. So with regard to the interpretation of treaties, the law prevailing at the time treaty is being interpreted shall prevail. Next, we have the amendment or modification. So to amend or modify provisions of the treaty, the consent of all parties is required. However, if allowed by the treaty itself, two states may modify provisions only insofar as they concern. Following is the termination of treaty. So the following are among of the grounds or causes for the termination of treaty. So first we have the expiration of the term, then the extension of one of the parties to the treaty, then the mutual agreement of all parties, then denunciation or desistance of by one part by one of the parties, then we have the supervening impossibility of performance, then we have the conclusion of subsequent inconsistent treaty between the parties, loss of the subject matter, material breach or violation of the treaty, the application of the doctrine of rebus sic stantibus, then the outbreak of the war between the parties, severance of the diplomatic relations, and lastly, we have the doctrine of jus cogens. Lastly, we have the termination procedure. So similarities. The procedure to terminate the application of treaty is the same. Then we have the countermeasure. It appears that a state trying to terminate a treaty may engage in a lawful countermeasure provided by the requisites. Then consequences. First is invalidation. So to determine, parties are required to be restored to their former status as if there had been no treaty. The next is the termination. So parties are released from their obligations, but no restorations to their former status needed. So followed by the suspension, treaty is released from their obligation under the treaty while suspension is in effect but still bound to refrain from acts tending to obstruct the resumption of the operation of the treaty. And lastly, the withdrawals. So generally, a withdrawal of a party will only affect the withdrawing party and not the treaty itself. However, where the instrument explicitly states that the treaty will be inoperative unless minimum number of states are parties to it. So I think we're done. So that was a long discussion, but thank you for listening till the end.